Hello, everyone. My name is Piotr Petas. I'm a PhD candidate at Stockholm University. My research in general explores the intersection of fashion and IP with a view towards sustainability. And the paper I'm about to present in specific examines how the copyright design law overlap has been affected by the case law of the Court of Justice of the European Union. It is somewhat the groundwork for my PhD thesis, which will explore how this newfound ground for copyright protection of fashion designs can be utilized to serve sustainability. As he summarized in this quote by A.J. Spooner in his opinion in Confirmal, fashion designs as works of applied art are still trying to find their place within the IP law system, while the protection compared to the distinctive signs of fashion brands by trademark law is quite straightforward, as well as the protection compared to registered designs. The situation in the realm of copyright is quite different. Fashion design's somewhat turbulent position within the copyright system is often attributed to the alleged cultural elitism of copyright law, separating works based on their worthiness of protection. Other works of both aesthetic and functional character, fashion designs have been a victim of the works of applied art versus pure art dichotomy, being refused equal treatment to other copyright works across the EU member states, with the only exceptions being the countries adhering to the unity of art, which dictates the equal treatment for all art forms, such as France and the Benelux countries. Even prior to the CJU ruling in Quebec and its progeny, one could have assumed that in order for copyright to subsist in the EU, there needs to be an author of a work that met the originality criterion. According to the landmark judgment in Infopac, copyright subsists in subject matter which is original in the sense that it is the author's own intellectual creation. Despite this attempt at harmonization, what complicated the fate of works of applied art is Article 17 of the Design Directive, which provided member states with the discretion to decide on the conditions for the protection of designs by copyright. Almost a decade prior to Confirmal and approximately 2 years after Infopac, the CJU attempted to shed some light to the copyright design right overlap in its decision in clause by indicating that designs are not to be treated differently than other works, also in terms of their copyright protection. Now, in 2019, the CJU issued its judgment in Confirmal, the first case in this span of the works of applied art case law, deriving directly from the fashion industry in the context of infringement proceedings between Confirmal and G-Star concerning some allegedly infringed designs of the latter. According to Confirmal, concurrent protection of copyright and design right can be emphasized as a different objective dictate, as long as both systems requirement are met. Confirmal's potential implications caused an intense debate regarding, among other things, whether it called for reevaluation of national legislation providing for different treatment among copyright-protected works on the ground of criteria such as artistic character or aesthetic value. One concern that persisted was this perceived expansion of copyright law, whether it could pose as a threat to design protection, and would also enhance this belief was the alleged contraction of design law by the Dostrom judgment that preceded Confirmal. Dostrom basically clarified with regard to design protection that the determining question for it to arise is not the existence of alternative forms, but rather whether function alone has determined the product's appearance, features. And following this case law, national courts were assigned with the task not to stretch these principles to a point of exclusion of too many designs from design law to an extent that copyright could completely overtake design rights' previous scope. Therefore, one of the main questions post-Confirmal was whether copyright will coexist with design law or whether it will render design rights less and less appealing. On the one hand, copyright protection typically arises automatically with the creation of the work and extends for 70 years after the author's death, at least in the EU. Registered designs require registration and therefore the payment of a fee, which is an upfront cost, and enjoy a maximum of 25 years of protection. And unregistered designs receive protection for a 3-year period without the need for registration costs. And on the other hand, especially unregistered designs are key in a fast-paced, trend-oriented sector such as fashion. Moreover, registered design rights protect irrespective of proof of derivation, which is the case for copyright. Thus, it is clear that both systems of protection present their own advantages. In order to assess Copyright actual impact on design rights, it might be practical to look into the data provided by the EU IPO regarding design registrations. First, even with a quick look, one can assume that in the decade preceding Copyright, registered designs flourished in the fashion industry. According to the EU IPO's Design Focus Report, RCD filings experienced an average annual growth rate of 3.5% between 2010 and 2019, and an overall growth rate of 36.2% when comparing the filing volume of 2019 with 2010. The fashion industry's RCD activity, which is manifested through the Locarno Class 2 registrations, ranked second in the list of most filed cases, following Class 6, the one for furniture. Furthermore, the number one top applicant for registered designs is footwear manufacturer and retailer Riker, American Athletic Footwear, and apparel corporation Nike follows in the second place, while French luxury fashion house Balmain is ranked fourth. Now, the current Class 2 design application filings in the EU from 2009 to 2015 remained steadily around 25,000 per year, only with the exception of 2012 when they reached 27,400. Following that, they faced an increase of 29,500 in 2016, peaking at 30,600 in 2017. Afterwards, they declined again, remaining around 25,000 for 2 years until 2020, when they showcased another significant drop by 5,000, reaching an all-time low point of 20,000 filings. So while 2020 was in fact the year after Copyright, one needs to also take into account the overall socioeconomic climate during the beginning of the new decade. More specifically, with COVID-19 striking, the world was compelled to tackle a pandemic for the first time, with all the implications this brought about. As a natural consequence, the fashion industry did not remain unaffected. According to the State of Fashion 2021 report released by the Business of Fashion and McKinsey, the average market capitalization of apparel, fashion and luxury players dropped almost 40% between the start of January and the 24th of March 2020, a much steeper decline than that of the overall stock market. Thereby, such a declination by 5,000 that was also noted between 2017 and 2018 for no apparent cause appears hard to be attributed solely to the Copyright judgment. This argument can be further supported by the consequent rebound of the filings to 25,000 again in 2023 after a 2-year adjustment period of fluctuation. Moreover, design registrations regarding Locarno Class 2 only faced a 0.6% decline between 2019 and 2020 when compared to the totality of design registrations, as in 2019, 6.8% of the design registration filings derived from Class 2, while in 2020, 6.2 of them. However, if one is to consider solely the design registration applications for Locarno Class 2, while the decrease to 20,000 does not appear to be groundbreaking, it does manifest a 20% decrease within a year. So whether Copyright should be held accountable for such a declination remains questionable. In order to add an extra layer to this analysis, also in hope of some clarity, I conducted interviews with 6 legal practitioners working with fashion brands based in different EU member states and thus having divergent backgrounds. The countries were chosen in a way which focuses on the practice in one of the countries with the most stringent artistic value tests, which is Italy, but also reflecting the approach of countries having embraced Unité de l'Art from earlier on, being France and the Netherlands. Of course, the addition of a jurisdiction with a neutral approach was also necessary, so that naturally was Switzerland. The question posed, all the questions posed concerning the protection of fashion designs as works of applied arts, pre and post Copyright, attempting to shed light on whether the fashion industry's legal practice is sensitive to legal changes by the CJU jurisprudence. The first question concerned a situation regarding fashion design's IP protection pre-Conformal. To no one's surprise, in countries such as the Netherlands and France, the dual protection of fashion designs by design rights and copyright was already provided for long before Conformal. The finding that perhaps was the least anticipated is that, according to the French practitioner, despite France's reputation as the birthplace of the community of art, it is not as favorable as one would expect, as it has set a test for originality, which, albeit it is applied uniformly for all types of works, is especially hard for fashion designs to pass, as proof for several stages of the creative process is necessary. For example, one pair of shoes, the design of one pair of shoes was defined because of designers' failed attempt to provide documents on the creative process of the soaps. As far as Italy is concerned, the first Italy-based practitioner refers to how the legal protection conferred to fashion design has overall evolved over the years in both traditional and collateral forms, with the latter also referring to copyright. According to another practitioner, the situation pre-Conformal was as simple as that any design meeting the requirements of the creative character and artistic value received full copyright protection. The third Italian interviewee stressed the vague character of their artistic value criterion, which Italy persists on, and underlined how the presence of that artistic value can only be ascertained ex post, clearly failing to adhere to the fundamental principle of copyright law that protection arises automatically along with the creation of the work. Lastly, the Switzerland-based practitioner emphasized how even before Conformal copyrights were relied upon cumulatively with design rights, as it was understood that the different protection systems have different objectives and complementary advantages as well. In the second question, the interviewees were asked to share their opinion on how Conformal shifted this status and whether it actually revolutionized the practices of the fashion industry. Again, as predicted, in the Netherlands and France, Conformal appeared merely as a confirmation of their court's existing standard. Fashion designs can be protected under copyright law just like any other type of work. In France specifically, however, Conformal did not make the originality assessment any easier for fashion designs as works of applied art, meaning that the factual background elements of the creation of the work are still considered essential to argue a work's originality, such as the artistic approach of the creator, something difficult to be proven, also given fashion's often collaborative nature. In Italy, the three different perspectives are all pointing to the same direction. Conformal did not revolutionize the practice in any way. According to one interviewee, Conformal was much ado about nothing, as the Italian system still conferred copyright protection only to high-end design products, and the acknowledgement of the product by the relevant circles is the proof it deserves copyright protection. Moving to the second Italian interviewee, it is pointed out that Conformal did not quite clarify on the matter of the criteria for copyright protection, thus considering this ambiguity on whether additional requirements are allowed and the fact that courts still apply the same standards, meaning the existence of artistic value. Big fashion houses still very much rely on design rights to protect their products. To no one's surprise, even the above mentioned, Conformal had so far never been acknowledged in a case concerning fashion design in countries that did not already provide for the copyright protection, namely Germany, Denmark, and Italy. Italy in specific did so in a case regarding the Kiko store layout, which is in any case an architectural design, a category of works to which no additional requirements were posed whatsoever. The Danish court, which in the past have granted copyright protection to works of applied art such as pots, but denied this protection to, for example, very distinctive rubber boots, acknowledged copyright subsistence on a work of applied art for the first time last August. It did so by referencing Conformal in relation to the famous Ghani Baku ballet shoes, which we can see on the left. In doing so, the US-based brand Steve Madden was found liable for copyright infringement for the shoes on the right, despite their claims that their shoe was only inspired by Ghanai's design as well as prevalent industry trends, arguments that were clearly not sustained. In conclusion, Cockwood's effect, in spite of its activist nature, was not radical after all. That is partly attributed to the fact that the court did not provide member states with the necessary guidance as to how they should apply its mandate. Therefore, it seems that copyright and the copyright and design right equilibrium in the fashion industry has remained somewhat unaffected, proving concern that copyright will completely overtake design rights to be wrong so far. Considering both design rights' inherent advantages and national courts' reluctance in applying Coffman's principles, fashion brands still turn to copyright protection mostly on a complementary level. But the future holds several developments for the copyright framework of works of applied art in the EU. As already mentioned, one of the main hindrances in Coffman's efficacy was the Design Directive's Article 17, Sentence 2, leaving the conditions for copyright protection designs to the discretion of the member states. This sentence appears to have been removed in the proposal for the design legislation, which was adopted in fact 2 days ago. Therefore, as member states are expected to implement this within 36 months, hopefully this problem will be resolved by 2017. These developments regarding the harmonization of copyright subsistence on works of applied art have raised several questions regarding their potential impact on the fashion industry too. Arguably, the IP regime for the protection of fashion designs per se has remained at a steadily low equilibrium, especially with the view to copyright. Some have attributed this to the piracy paradox, meaning that the fashion industry is paradoxically economically benefited by design copying, by the overproduction / overconsumption driven by these rabbit circles of trend immersion and diffusion. Others have claimed that simply the ability to effectively protect fashion design with IP rights is to blame for this situation. Now that the possibility to also protect fashion designs by copyright has become clearer, both perspectives can be tested in a way. If the latter is true, can IP protection be used as a tool against copying to target fast fashion, which is essentially built upon a business model of design copying and eventually slow it down? But IP has been referred to as a double-edged sword with regards to sustainability in the fashion sector. Could this newfound ground for copyright protection hinder even more so sustainable practices in the fashion industry, such as upcycling? These are, among other things, the questions that will hopefully be addressed in my doctoral thesis, but I would be more than glad to discuss them with you. Thank you so much for your attention. Here you can find my email and my contact details in case you have anything you'd like to